All right. Can you hear me? Okay. Good afternoon, everyone. Thank you so much for coming. My name is Brendan Collins. I'm one of the co-presidents of the LGBT Law Forum here. And I just want to start by thanking everyone and our panelists for coming today. This is an amazing event. We're so excited. We have a great panel to discuss whether Title VII of the Civil Rights Act prohibition on sex discrimination encompasses discrimination on the basis of sexual orientation and gender identity. The purpose of this panel is to provide an overview of circuit precedent and varying treatment of Title VII by federal agencies. We will also preview the Supreme Court's forthcoming decision on this important legal question. We will begin by introducing our panelists, and then each member of our panel will speak for about 10 minutes. We will also hold about 10 minutes for questions at the end of the panel's discussion. Before we begin, just a few logistical things. We'd also like to thank our co-sponsors for this event, the American Constitutional Law Society and the Women's Legal Forum. Thank you both so much. We also will have food served after the event in front of room 1130, which is just right out front there. And now our treasurer, Jamie Perrone, will introduce our speakers. Thank you.
Hello, everyone. Thank you again for coming to this event. I'm here to introduce our wonderful speakers. So we have Steve Sanders, who's a professor at Indiana University Maurer School of Law, where he teaches constitutional law, family law, constitutional litigation, conflict of laws, and seminars on constitutional interpretation and judicial review. His scholarship focuses on questions arising out of the 14th Amendment's guarantees of equal protection and due process, with a special focus on issues affecting LGBTQ persons and same-sex couples. In addition to his scholarship and teaching, Sanders has participated in groundbreaking litigation on behalf of the Human Rights Campaign. He co-authored an amicus brief to the U.S. Supreme Court in Obergefell v. Hodges, which established nationwide marriage for equality for gays and lesbians. A case he litigated in the Indiana Court of Appeals in 2013 led to the first published opinion by any court in the United States, holding that a spouse's gender transition did not affect the validity of an existing marriage. Sanders' writing has appeared in the New York Times, the Huffington Post, the SCOTUS blog, among many other print and online outlets. He's appeared on MSNBC and public radios to the point, is a regular legal analyst for Bloomberg Radio, and is frequently quoted by print and online news media about matters of constitutional law, LGBTQ rights, and the Supreme Court. We also have Kim Hively, who is a lifelong South Bender who served as the named plaintiff in Hively v. Ivy Tech, the groundbreaking case that led the Seventh Circuit Court of Appeals to rule en banc that workplace discrimination based on sexual orientation violates Title VII of the Civil Rights Act. And this came after Lambda Legal urged the court to reverse a lower court ruling and allow Ms. Hively to present her case, alleging that Ivy Tech Community College, where she worked as an instructor for 14 years, denied her full-time employment and promotions and eventually terminated her employment because she is a lesbian. Ms. Hively is the proud product of Michiana Public Schools and holds an undergraduate degree from Bethel University and a master's degree from Indiana University. She worked as a math teacher for 17 years and continues to tutor, in addition to her bookkeeping work in the business sector. And our final panelist is Eduardo Juarez, who is a supervisory trial attorney with the San Antonio Field Office of the Equal Employment Opportunity Commission, where since 2001 he has litigated individual and class lawsuits about federal civil rights statutes prohibiting employment discrimination. In August 2011, he worked on detail as a special assistant for former EEOC Commissioner Chaya Feldblum, the first out lesbian EEOC commissioner. From 1990 to 1999, Mr. Juarez was a trial attorney with the Public Defender Service for the District of Columbia. And from 1987 to 1989, he was an associate with the law firm of Sidley & Austin in Chicago, Illinois. Mr. Juarez received his BA in philosophy from the University of Notre Dame in 1984 and his law degree from the University of Michigan in 1987. In 2017, he received the American Bar Association Stonewall Award for his advocacy work on behalf of the LGBT community. Mr. Juarez is a past president of the National LGBT Bar Association and a past chair of the LGBT law section for the State Bar of Texas. He is currently a member of the ABA's Commission on Lawyer Assistance Programs and of the Texas Lawyers Assistance Program Committee for the State Bar of Texas. So please join me in a round of applause in welcoming our fabulous panelists.
So I think I'm going to need some technical help here. All right. So thank you everyone for being here. Thank you to the LGBT Law Forum and all the organizations that are sponsoring this. You know, I've got a lot of slides, a lot of information. I'm going to skip through some because I made a mistake of putting too much information and too many slides on this. But this is what we're talking about here today is a statute and statutory interpretation. So the pertinent part of Title VII is on the slide. It states it deals with employment discrimination. An employer cannot discriminate against any individual with respect to employment because of such individual's sex. The statute itself doesn't provide a comprehensive definition of what because of sex means. I think the other important thing about the statute itself is that all you need, in terms of causation, all you need is a motivating factor. Sex just needs to be a motivating factor. Doesn't have to be the sole factor or the only factor. There could be other motivating factors, so sex just needs to be a motivating factor to be a violation of Title VII. Really, the seminal case on the legal relevance of gender stereotyping is a case from 1989, Price Waterhouse versus Hopkins. And the facts in that case are that there was a woman, Ann Hopkins, who was up for partnership at Price Waterhouse. And in making the determination about whether to promote her to partner, there was some evaluative comments made by the partners, written comments. And in those comments, the partner stated, described her as being too macho. She cursed like a sailor. She needed to go to a charm school. And the partner who told her that she was not being promoted to partner had told her that, advised her that her chances would be better, the following time if she walked more femininely, talked more femininely, dressed more femininely, wore makeup, had her hair styled, and wore jewelry. This is an important case because the court, in essence, said that taking gender into account violates Title VII, and the court held that this evidence was gender stereotyping, and in general, the definition of gender stereotyping is conduct founded on the insistence that men or women comply with stereotypical gender norms. So another important Supreme Court case for this issue is Oncoli versus Sundowner Offshore Services. This case deals with statutory, and really the pertinent part of this case that I quoted deals with statutory interpretation. And it basically is an opinion written by Justice Scalia. And what Justice Scalia is saying by this quote is that the method of interpreting statutes is textualism. You don't look at what was the concern of Congress or was the intent of Congress. What's most important is a textual analysis. You look at the words of the statute. And so the quote is, statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. This was a same-sex harassment case where there was an argument on the other side that said, you know, that's not covered by the statute. Legislators didn't intend that, and so Justice Scalia said, well, you look at the text, same-sex harassment is clearly, the text applies to that. So I'm going to go through these two slides pretty quickly because this just recognizes that in 2004, there was a transgender firefighter who, in essence, won a case before the Sixth Circuit using the gender stereotyping theory of Price Waterhouse. And I think the important quote in that is, discrimination against a plaintiff who is, and this is a quote from the case, a transsexual, and therefore fails to act and or identify with his or her gender is no different from the discrimination directed against Ann Hopkinson Price Waterhouse. So this was a trans female who was suspended when she started expressing more femininely, and in essence the court applied Price Waterhouse pretty straightforwardly. Then we get to the case that's actually the case that's up before the Supreme Court. It's a Sixth Circuit court case. And it's EEOC versus Harris Funeral Homes. The EEOC was the plaintiff in this case, and it was filed by the Detroit District Office of the EEOC. And general facts in that case is that Aimee Stephens was a funeral director. She sent a heartfelt letter to the owner of the funeral home, explaining to the owner that she had been pretty much suffering with a gender identity disorder and was going to start presenting as a male, and indicated that she would start presenting as a woman, and indicated that she would also be dressing in appropriate business attire, but as a woman. 2 weeks later, she was fired, and the owner, in deposition testimony, admitted, you know, that the reason that he fired her was because she was no longer going to represent as a man, and because she wanted to dress as a woman. So the EEOC sued two basic claims, or it's the same claim, but it's under sex discrimination, but saying, you know, under Price Waterhouse, there was a gender stereotyping claim, but also, apart from gender stereotyping, when you discriminate against a person because of their transgender status or transitioning status, that in and of itself is sex discrimination. The lower court, the district courts that narrowed the EEOC's claim and said, yes, you can go forward on the gender stereotyping claim pursuant to Price Waterhouse, but with regard to the standalone transgender status claim, you cannot go forward on that because Title VII doesn't cover that. The Sixth Circuit said that what the district court did in narrowing the EEOC's claim was error, and held that discrimination on the basis of transgender and transitioning status alone is necessarily discrimination because of sex. It gave two basic reasons. First, the court said that it was analytically impossible to discriminate based on an employee's transgender status without being motivated in part by the employee's sex. The employer, the owner, had said in his deposition testimony that it was wrong for a biological male, that's his words, to deny his sex by dressing as a woman. So you see, even in the employer's own statement about why he fired Aimee Stephens, he's using sex as a factor. It's because, according to him, a biological male is denying his sex. The court also made an analogy to when you, for example, if you fire someone because they're a religious convert. In other words, an employer might not be biased against Catholics, might not be biased against Jews, but if you convert from Catholicism to Judaism, then you're fired. That's clearly discrimination because of religion. And so the court said there should be no difference really with the protected category of sex. If you're firing someone because of a change in sex, it's the same thing. It's discrimination because of sex. The second reason that the court gave was basically using Price Waterhouse, the gender stereotyping, basically saying that by definition, a transgender person is inherently gender nonconforming because the very essence of being transgender is a disjunction between gender identity and the sex assigned at birth. There's a lot of arguments that the court refuted that were arguments put forth by Harris Funeral Home. I'm going to try to go through these relatively quickly, but one is that the funeral home said, look, we're applying a dress code both to males and females, and it's not sex discrimination because we would have fired a woman who had wanted to comply with the men's dress code, and so it's not sex discrimination. But what the court said was that, you know, that's not the issue before us, whether or not the funeral home's dress code violated Title VII, because Stephens had stated that she was going to abide by the dress code. I mean, the real issue was that she was refusing to conform to the employer's notion of her sex. And the court also pointed out that under Price Waterhouse, it wouldn't have been a defense for the employer to say, well, it's not discrimination to fire Ann Hopkins because she's gender nonconforming, because we fire males who are gender nonconforming too. That wouldn't have been a defense. It would have been two wrongs, according to the court. So there was more arguments put forth by the funeral home that were refuted by the court. The first, and I apologize for putting way too much text on this slide, but the first and the third arguments really have to do with congressional intent. You know, the funeral home was saying that the Congress enacting Title VII understood sex to refer only to physiology, not gender identity. Again, the court went back to the young colleague, to the quote that I gave that said the text is the lodestar, you don't look at congressional intent. There was also some argument about like transgender status is not unique to one sect. There's both transgender men and transgender women. But the court said, you know, Title VII discrimination is based on classification, not class. You look at the individual, not the entire class. The final thing was that there was an argument that said, look, in later statutes passed by Congress, there was an explicit protection for gender identity. So that shows that Title VII, since it's not explicit, sexual orientation, that means that it's not covered. But again, the court said that the Congress could be choosing to use a belt and suspenders method to achieve its goals. But in any case, again, you look at the text, you don't look at the at congressional intent. So that's the case law with regard to gender identity. And now I'm going to switch a little bit and go to the case law that dealt with sexual orientation discrimination. Very quickly, there's been a series of Court of Appeals cases that where you know, a gay individual or a lesbian individual would bring forth a claim based on Price Waterhouse. And in this case, this is a Ninth Circuit case from 2001, where there was a waiter that was harassed, and really the terms used for the harassment indicated that he was being harassed because of his, he was not masculine enough. I mean, they used the F word, like the derogatory terms towards gay men, called him a female whore, and they mocked him for walking and carrying and serving his tray like a woman. The court there said that that's clearly harassment based on sex, because it's based on the fact that he was not conforming to how a man should act under Price Waterhouse. Then you come to the the case of Professor Kimberly Hively, and I apologize for talking about you in the third person. I'm glad you're here. And so in this case, this was actually really the first federal court of appeals case that went beyond just gender stereotyping for sexual orientation, but said, look, when you discriminate against someone based on sexual orientation, that is sex discrimination under Title VII. The facts in that case are that Professor Hively, who is a lesbian, was a part-time adjunct professor. She unsuccessfully applied for 6 full-time positions. And then between 2009 and 2014, and then the school did not renew her contract, and she sued alleging sexual orientation discrimination. Again, the district court dismissed it, saying that sexual orientation isn't covered by Title VII. There was a first, it's called a panel decision by the Seventh Circuit, meaning there was 3 judges of the Seventh Circuit that decided, following precedent, they agreed with the district court and were in dismissing Professor Hively's case. But then the Seventh Circuit en banc, meaning the entire, all the judges on the Seventh Circuit, then heard the case and they overruled and basically followed, they also followed Oncoli's instruction that the text is the lodestar. These are the reasons given by the Hively case, or the Hively court. One is the comparative method. Had Professor Hively been a man married to a woman or attracted to a woman, she would have been promoted and not fired. That's paradigmatic sex discrimination. Sexual orientation is the ultimate failure to conform to sex stereotypes. Basically, the stereotype is that all women should be attracted to men. And the court also said that the line between, if you recall me saying there was a lot of cases that it was like a hodgepodge of cases, and they couldn't really, the courts were having trouble distinguishing between claims that were based on gender nonconformity and claims that were based on sexual orientation. And here the Seventh Circuit said, you know, the reason the courts are having such problems is because there is, that's a fiction, that line, and said there is no difference. The third reason given by the Hively court is association, a kind of a comparison to where an employee might be fired for interracial association, like a white individual would be fired for being married to a black individual, and that's clearly race discrimination, so the same logic should apply for sex discrimination. I also wanted to point out that Judge Flaum's concurring opinion is basically just a logical argument saying that when you discriminate against someone based on their sexual orientation, that necessarily means you're discriminating against someone because of the employee's sex, and their sexual attraction to the same-sex individuals. So in essence, every time you discriminate against someone based on their sexual orientation, sex is a factor, and remember what I stated at the very beginning, all you need is for it to be a motivating factor. You don't need for it to be the only factor. Judge Posner's concurring opinion is interesting because he pretty much says, look, looks beyond the textualism and says that judges, in his opinion, judges should be updating statutes based on present need and understanding, not original meaning. And I think he is a rebel judge on that point. So this is the Zarda case, which is very similar to the Hively case. And this is the case that went up to the Supreme Court on sexual orientation. Mr. Zarda was a gay skydiving instructor. He told the client he was gay, and the reason he told the client he was gay was because, being a skydiving instructor, his clients were pretty much strapped shoulder to shoulder and hip to hip to him. And so sometimes when he had female clients, according to him, he would kind of try to alleviate any concerns they might have by telling them that he was gay. But this one client told her boyfriend and her boyfriend told the owner, and then Mr. Zarda got fired after that. There was also an allegation which Mr. Zarda denied, that he had inappropriately touched the client, but in any case, he brought a claim for sexual orientation discrimination under Title VII. The district court just followed precedent in the Second Circuit and said that's not allowed under Title VII, and Zarda appealed. It again went to the en banc court of the Second Circuit, and the court held that sex is necessarily a motivating factor in discrimination based on sexual orientation, and gave, in essence, the same reason as in the Hively Seventh Circuit case. You know, the logic argument saying that he's a man, firing a man because he is attracted to men is a decision motivated in part by sex. The comparative analysis, the stereotypes, same-sex orientation represents the ultimate case of failure to conform to gender stereotypes, and then the association comparison to race association cases. There are a lot of more arguments that the employer put forth. I'll kind of note the first three. One is the argument that really the central public meaning of because of sex in 1964 just did not include sexual orientation. And so, again, I think the counterpoint to that is that Oncali instructs that the text is what matters. There's also a lot of comparisons of who the proper comparators are. Is it a gay man versus a gay woman, or is it a gay man versus a straight woman? And, you know, when reading all the briefs and the cases about these comparisons, I realize why they say that math majors make very good law students, because there's a lot of logic involved in that. And then there was also a lot of talk about, by the employer about that if you rule in favor of Zarda, that this would be the end of sex-segregated bathrooms and sex-based grooming standards. And the court said, no, that's not true, because yes, it is. Those policies are because of sex, but you still have to show injury. You still have to show that such policies impose disadvantageous terms and conditions of employment. I will point out that in this case, in this Zarda case, the EEOC filed an amicus brief, that's the federal agency that I work for, saying that Title VII covers sexual orientation and gender identity. That's been the EEOC's position in terms of gender identity since 2012 in a decision by the EEOC called Macy, and since, I believe, 2015 in the Baldwin case for sexual orientation. Most of the Department of Justice had followed the EEOC's position on that and had pretty much was in line with that position. But in the Zarda case, the Department of Justice filed an amicus brief that was directly counter to what the EEOC's position was, saying that Title VII was not did not cover sexual orientation and gender identity. The EEOC can represent itself in the federal courts of appeals, for example, in the Harris v. Funeral Homes case, but when it comes to the Supreme Court level, it is the Solicitor General of the United States that represents the federal agencies. So the Solicitor General is part of the Department of Justice. So, for example, in the Harris v. Funeral Homes case, you had the Solicitor General arguing against the EEOC's position. But the ACLU had intervened in the Harris v. Funeral Homes case, so they, in essence, argued what is the EEOC's current position still. It hasn't been reversed. Because the department, these are attorneys that I stood in line with. I woke up at 2 a.m. On October 8th, got in line by 3 a.m. These are all attorneys from the EEOC. Some of these attorneys worked on the Harris v. Funeral Home case. Actually, most of them did. This is a picture of some former EEOC political appointees. The former general counsel, David Lopez, the first out commissioner, lesbian commissioner of the EEOC, Hively in the middle, and the chair, Jenny Yang, the former chair, also who were in attendance at the Supreme Court. So I think I'll stop there, and I may have gone over time, but sorry. Thank you.
You want me to go ahead? Okay. All right. We'll go out of order here. So, where are we on time? 25 minutes. Okay. Okay. So, as Eduardo said, I think my job is to sort of pick up and describe what happened at the Supreme Court arguments, and also a little bit putting it into context, evaluating the arguments and what may happen in the future. So before the court last week were two cases. The Zarda case, sexual orientation. Is sexual orientation a form of discrimination because of sex and thus prohibited by Title VII? And then the second case, the Harris Funeral Homes case, is discrimination against a person because of their gender transition, their change of gender identity. Is that sex discrimination? And thus illegal under Title VII. In the background here is a debate. Is this about updating the meaning of statutes? Is this about, taking account that sex and what it means to discriminate against sex and the insights that queer theory and gender studies have given us about the sort of roots of homophobia and transphobia in attitudes about gender? Is that what this is about? Or is this just a very sort of almost hyper formalistic argument? No, it is because of sex. If the female employee wants to date a male, that's fine, but if the male employee wants to date a male, that's not fine, and they get punished for it. That just seems like straightforward discrimination because of sex. And similarly, if the formerly male employee of the funeral home now presents as a woman, and the employer doesn't like that, that is because of their sex. And also, in both cases, it's because of the kinds of gender stereotypes. What is the appropriate way for men and women to appear in the world and function in the workplace that the court said in Price versus Waterhouse were not permissible? Advocates in both cases on behalf of the plaintiffs took great pains to say this isn't about the court changing the meaning of Title VII or what Congress did in 1964. This is just taking the word sex and applying it in this particular situation. My sense from the arguments is that if there is one justice, I think it's safe to assume we have a 5-4 court with generally acknowledged 5 conservatives, 4 progressives. I think the 4 progressives are likely to be with the plaintiffs in this case, with Zarda and with Aimee Stephens, because they would accept that what the lower courts did in these cases is, at the end of the day, fairly straightforward statutory interpretation, nothing particularly out there or adventurous or controversial. On the side of the conservative justices, my sense is that if one of those justices is gettable in these cases, just again, based on his participation at the arguments, which was quite active in both the gender identity and the sexual orientation case, it may be Justice Gorsuch. Justice Gorsuch is, so these cases highlight also, I think, a tension in what it means to be a so-called legal, a quote-unquote legal conservative or a judicial conservative in the statutory interpretation context. If you read Justice Sykes' dissent in Kim Hively's case from the Seventh Circuit, she refers to textualism, but what she's really talking about is Congress in 1964 couldn't have possibly thought that in banning sex discrimination, they were also banning discrimination against gays, lesbians, and transgendered people. Well, that gets to congressional intent, or it gets to original public meaning. Those are also ways of approaching a statute and ways of approaching constitutional text, but they're not necessarily the same thing as textualism. Textualism tends to be, again, more formalistic. The word says discrimination on the basis of sex. The employee wants to date a man, and she's a female, whereas if she wanted to, the employee wants to date a woman, and she's a female. If it were a male employee, same thing. They wouldn't have been fired. That's discrimination on the basis of sex. So Justice Gorsuch kind of indicated he was all but persuaded by that argument. Again, it's a formalistic kind of argument, but sometimes that kind of formalism, I think, appeals to textualists. He was concerned at what he talked about in the gender identity case, the funeral home case, about what he called them, well, I'm kind of with you, counsel, on the sex discrimination argument, but wouldn't it cause massive social upheaval for the court to do this, and isn't it more appropriate for Congress to do this? And I think one argument is this understanding of Title VII and gender identity is already the case in, I believe, a majority of the federal circuits. I think more than half the country is covered by federal judicial circuits where that's already the reigning interpretation. And so this wouldn't be that massive an upheaval for the court to simply confirm the correctness of those interpretations. On the other hand, again, you have this sort of conservative approach to this issue, which says, well, this is really about sexual orientation at the end of the day, or it's really about gender identity, and it's kind of a backdoor argument or a creative argument to say it's on the basis of sex, when we all know what's going on here. It's homophobia and transphobia, and if you want to address that, talk to Congress. Justice Alito, in the sexual orientation case, the Zarda case, I think thought he really had a point there when he said, well, imagine this hypothetical. An employer comes to a boss and says, I've just interviewed 2 candidates for this job. I'm not going to tell you their gender or their sex, but one of them likes to have relationships with members of their same sex and the other doesn't, and the employer says, well, we're not going to hire that person, and that keeping it blind as to the person's sex in that situation proves that this is really about dislike of gay people or dislike of lesbians. It's about sexual orientations, not sex discrimination formally. A sort of the funniest moment in the argument, I thought, Pam Carlin from Stanford, who's representing Zarda, misunderstood the question a little bit, and I think she said, oh, you mean it's like Pat from Saturday Night Live, the person whose gender is just ambiguous. And Justice Alito said, I don't understand the reference. And you could just imagine Pam Carlin, the word balloon over her head, saying, why am I not surprised at that? But he doesn't get that reference. So in terms of what the opponents, what the advocates on the other side, including the Trump administration in these cases, the Trump administration is formally on the side of the funeral home and the employer who wants to be able to discriminate against gay people. Much of the argument was a sort of parade of horribles, and that's not to say these aren't tough issues to resolve. So in the gender identity case, the question becomes, okay, if you say that a person who was assigned at birth as a male is now a female, does that mean that that person must be employed by a women's shelter at a place where women who have been traumatized by men, by male relationships, may be threatened by men, are they truly going to see this person as a woman, even though that is the way they identify? They may have had surgery, they may have hormone treatments. People at the end of the day are going to say, no, that's a man. Are you saying that the women's shelter has to hire the transgender woman? And I think that's a tough question. And I'm not sure there was a satisfactory answer to that, other than to say there will be exceptions. It could be that there is a bona fide occupational qualification that does actually look to biological sex or sex assigned at birth as necessary in that situation. There was lots of talk about bathrooms in both cases. Too much for my tastes in some ways. But in the response to that is basically, yes, the issue of which bathroom a person uses based on their sex or their gender identity is a question, but that's not what these cases are about. The bathroom question, whether forcing you to use a men's washroom when you want to use a women's washroom, whether that is an injury of some kind or not, may be an interesting legal question, but it's a different legal question than whether you fire somebody or fail to employ somebody or treat someone in a disadvantageous way because of their gender identity or because of their sexual orientation. My own take on this has long been that the argument, the argument that these forms of discrimination are sex discrimination and thus covered by Title VII. Sort of, if you support the idea that there should be actions available for people who, gays and lesbians and bisexuals and transgender people who've been discriminated against, it sort of gets you where you want to go. It's useful in that sense, and I get the logic. putting on my hat as somebody who used to do LGBTQ political advocacy before he became a lawyer and a law professor, I do think we have to acknowledge that it does avoid confronting the real issue. At the end of the day, if somebody discriminates against a gay or lesbian person, I think, Justice Alito is onto something. It is because they don't like gay people as gay people, or they don't like lesbians, or they have hang-ups about sexual orientation, or they have hang-ups about gender identity. And so I think there is value politically in a democratic society in naming that and using the expressive power of law to legislate against it. If we think the problem is discrimination on the basis of sexual orientation, no doubt the better approach, the more favorable approach as a democracy is let's pass laws that say that. And name the problem and attack the problem directly. In some way, this sort of bootstrapping approach using Price Waterhouse, as I said, sort of gets us to that end where there is a legal remedy available. And I don't want to be misunderstood. I'm not seeking to undermine in the realm of statutory interpretation that does seem to be a valid argument, kind of formalistic though it is. But again, it doesn't use the expressive power of law to say it's time to name this form of discrimination and say we as a city or a state or a nation are against it. I'll just make one final point and then turn it over to Kim. As I suspected we would, we did hear concerns in these cases from some of the justices. Is this really our role? Isn't this something Congress should do? What should we take from the fact that Congress has had many opportunities to do this and hasn't done it? I had some slides, but I'm not going to take the time to show them. If you look at the polling data on this question, since the 1990s, supermajorities of Americans, and by that I mean above 80%, consistently have agreed with the proposition gays and lesbians should have equal rights in terms of job opportunities. I haven't seen polling, perhaps there's been polling on the gender identity question as well, but the support for that proposition for gays and lesbians is so overwhelming that Gallup stopped asking about it. So that's not to say I'm arguing that, well, judges have to step in and do it because Congress hasn't, but it does, I think, cause us to pause and think about, does our democratic political lawmaking majoritarian system that is pointed to when judges and legal conservatives say, well, don't take your argument to appellate judges, take your argument to Congress. Well, it's not working if vast majorities for 20 years or more have favored this as a matter of public policy, and it's been subjected to bottlenecks. It doesn't get done. Nancy Pelosi's House of Representatives has passed the Equality Act, which would basically accomplish this, but we all know that as long as Republicans control the Senate and as long as Senator McConnell maintains control over the Senate agenda, nothing like this is going to happen. So I would say, sort of spare me the lectures about using the legislative process rather than the judicial process to accomplish this when the legislative process clearly does not work in the sort of schoolhouse rock way that we're told it is supposed to work. So thanks, and I'm happy to answer any questions after Kim has her say.
Good afternoon. My name is Kim Hively. I am a lifelong resident of South Bend. I don't have any new laws to tell you about. I only have a story to tell you. My journey began late in 2010 when I felt like I was being discriminated against by the people that I worked for. I wasn't sure what to do about it. So my first stop was at the Human Rights Commission in South Bend. They directed me to an EEOC filing. And if you know anything about the EEOC, they send a letter to your employer, and my employer didn't respond, and didn't respond, and didn't respond. So 6 months afterwards, I received a letter in the mail that I had the right to sue. So I then started looking for an attorney. Well, the state of Indiana has some funny employment laws, and finding an employment lawyer in South Bend was, well, it was a journey in itself. But basically, I was told that nobody would take the case. I didn't have a case, and good luck. So I contacted a friend of mine who is a lawyer, not a criminal lawyer, but just helped me with some of the language, and I filed the lawsuit pro se. I was angry, and I get stubborn when I'm angry, and so I filed a lawsuit even though everybody told me I couldn't win. Well, as predicted, my lawsuit was denied, and it was just about ready to run out of time for me to appeal when I got 2 phone calls within 2 days of each other. One was Lambda Legal, and the other one was the ACLU. I decided to stick with Lambda Legal since my issues were their journey. I got hooked up with a brilliant lawyer who really worked hard on my behalf. His name is Greg Nevins. He travels all over the country. I think he's out of Atlanta, Georgia, typically, but he was in Chicago a lot for a couple of years. He filed the appeal. The court in the 3-judge panel, it came down to this. We want to rule in your favor, but the law says we can't. So we have to dismiss your case. So because of the language that they used, Mr. Nevins decided that he was going to ask for an en banc trial. And he was granted that, and he said it's a really hard thing to get. Normally they tell you to go away, and he was granted that. And so he argued again, and his argument was, as these nice gentlemen have explained, it wasn't about my sexual orientation, it was about gender and sex discrimination. So they won, and everybody was very excited, and I was very excited, except that I kind of got to start where I began. No lawyer, no employment lawyer in South Bend to talk to, and I still just needed to file a court case. So Lambda Legal was nice enough to help me out with that and find me some representation, and thankfully it finally came to resolution. But it was 5 years from the time I initially filed my EEOC complaint until the end of everything. So it was a long journey. It was a lot of hurry up and wait. Sometimes it was 10, 11, 12 months before the next step got taken. As you all know, courts can be very slow. And mine wasn't a huge issue, although I got lots of phone calls and lots of press, which was great. And I did all of this because I was angry and stubborn. And even though people told me that I absolutely could not do it and I could not win, I thought it was not right. So I did it anyway. Okay? And
That is the story of civil rights plaintiffs throughout our history.
Okay, so it looks like we have about 10 minutes for questions, but before we get into questions, can we thank these panelists again? So we have a handheld mic, but if you don't feel like you need it, that's fine. I will just point you out, and you can raise a question to the entire panel, to a specific panelist, or I'll try to help you out along the way. Yeah.
So do the defendants in Zark and Harris try to use the religious freedom argument
Do you want me to address that?
In the Harris Funeral Homes case, yes, they did. They used the Religious Freedom Restoration Act, and at the district court level, they won on that point. But at the Sixth Circuit Court level, the Sixth Circuit reversed and said no, that the RFRA defense was not substantiated.
At the Supreme Court, in neither case is a religious liberty sort of First Amendment defense directly in play. It's just, is this or is this not because of sex? However, the defendant funeral home in the Harris case is represented by the Alliance Defending Freedom, which is a prominent conservative religious liberty organization. So that, I think, sends a big signal that that they think this issue is sort of bound up with religious liberty. And there's no question that the religious liberty implications of this, and if Congress does it, they can have a carve out, but if the court does it, does that trample on religious liberty? Those questions are floating around, but they're not central to to the question before the court.
And at the oral arguments, Justice Roberts asked the question, well, if we rule in favor of the employees in these cases, what happens to the religious liberty argument, kind of, because he had pointed out that a lot of state legislatures, when they pass legislation that protects LGBT workers against discrimination, they also usually include a religious exemption. But of course, this is a court, not a legislature, so Justice Roberts was indicating some concern about that. But the response from the attorney was that Title VII already has like some co-religionist exemptions, and also the court itself has ruled in its cases that there's a ministerial exception for churches or religious organizations.
Well, and also the statistic was given that 85% of employers in this country, excuse me, are not actually covered by Title VII because so many employers are small businesses, and you have to be an enterprise above a certain number of employees before Title VII even kicks in.
So I'm here with 30 Introduction to Gender Studies undergraduate students. So we're happy to be here, and we're talking in our class a lot about these same issues. And one thing that I'm curious about is looking forward, if you see a more expansive formalist reading of sex to cover discrimination based on sexual orientation and gender identity, what does that mean for all of the campaigns that have focused on adding sexual orientation and gender identity to workplace and municipal and state anti-discrimination codes or statutes? Is that energy we should no longer focus on? Should we let that go? Is that a since the stutters development of stutters thing we should continue pursuing?
Sure. Well, one observation is sort of in the wake of the marriage equality victories, there really hasn't been any substantial movement toward gender or toward sexual orientation or gender identity non-discrimination laws. We're still stuck at 22 or 23 states, not including Indiana, that have them. But I mean, if the court were to give victories in one or both of these cases, that wouldn't be the end of the fight. As I mentioned, Title VII only doesn't cover 85% of the employers in this country, whereas state laws that prohibit discrimination on the basis of sexual orientation or gender identity can cover smaller employees as well. And these cases are only about employment. They're not about discrimination in education, in housing, in places of public accommodations, whether the baker, the restaurant, the dry cleaner can turn you away because of your sexual orientation or gender identity. And those subjects are typically addressed by state laws. They're not addressed by Title VII. So I think a win in the Title VII case for the people who brought these cases would perhaps add to the momentum. I mean, you can game out either way, that it might, well, the courts can take care of this for us, versus, okay, we got this, now we can make this argument in a way that's all the more compelling to reach other employers, to reach places of public accommodation, et cetera.
I can add to that a little bit as the employee. I live in South Bend, where I was supposedly protected. However, the place that I worked was a state agency, and so that made me unprotected. So the fact that my city and state can't decide what the best route to go is, and they were at the time still arguing for the county to be included in this discrimination, I was stuck between a rock and a hard place. Even though I felt like I was protected because I live in a city, that is, because of the person that I worked for, I was not.
I'm curious, so how likely is it that the Supreme Court splits on the sexual orientation discrimination question and the gender identity question, based on the distinction that you were making, Professor Sanders in particular?
And I'd be curious to know what Eduardo thinks as well. I mean, I think there's a decent chance. I mean, again, Justice Gorsuch seemed all but persuaded by the sex discrimination argument in the funeral homes case, in the gender identity, the trans discrimination case. Again, and then his concern was sort of judicial modesty. Should we be the ones who are doing this? Supposed massive social upheaval, which there won't be. So I think there's a decent chance, and professor friends of mine who teach statutory interpretation have agreed that if one of these cases has a better chance than the other, it probably is the one involving the transgender funeral home employee, that just feels intuitively somehow more naturally to be about sex and discrimination on the basis of your gender and how you present to the world, whereas the sexual orientation argument, even if you buy the formalistic argument that is still at the end of the day on the basis of sex, feels a little bit more like a stretch or a little bit more of a creative argument. So I mean, I think there is a decent chance, and I'm not good at predicting these things. But I mean, I think, again, if there's one justice that's gettable on the conservative side, at least in one of these cases, it might be Justice Gorsuch. I would say just one last thing. Justice Kavanaugh was pretty quiet in both arguments. He reviewed a book, back when he was a circuit court judge, he reviewed a book in the Harvard Law Review, a book about statutory interpretation that was written by the author of the Zarda case in the Second Circuit, the judge on the Second Circuit who wrote the opinion that said this is a form of sex discrimination. And Justice Kavanaugh, in his book review a few years ago, said this guy really knows what he's talking about. If you want to know about statutory interpretation, read this judge's book. So I'd be curious to know whether that's kind of hanging over him as well.
I thought that Justice Gorsuch, he stated several times, I'm with you on the textualism. He stated it several times. He says it's he used the word very close. And to me, if he is deciding based on textualism, I think it'll be very hard for there to be an opinion where the sexual orientation wins and gender identity loses, or the other way. Because I think both of them, if you take the textualism argument, both of them win.
So you think he'd have to be consistent in both cases?
Yeah, he'd have to be consistent because, because the textualism argument for sexual orientation is like it's a man. You're discriminated against a man who is attracted to another man. So sex is a factor. It's just formalistically, linguistically, logically. And so I think that it'll be difficult for him to have that split. I think where the split may happen is that they will say, they'll kind of keep the status quo, which is people that are LGBT can bring a claim and try to fit it under the rubric of Price-Waterhouse gender stereotyping. And just like and then the Court of Appeals will be this hodgepodge of decisions, kind of like where they'll still be trying to figure out, well, is it a gender stereotyping claim or is it a sexual orientation claim? And that might be.
But that would be a potential mess, right? Because if you're doing that, you're more likely to succeed if you're an effeminate gay man than if you're a masculine gay man who can easily pass. And you'd say, well, they're discriminating against the gay man who likes to cook and sew. That is a gender stereotype. But the guy who goes to the gym and plays football and hangs out with his straight buddies, nobody's gender stereotyping him. Well, the argument is, at the end of the day, who he wants to be romantically and intimately involved with, that is still a gender stereotype. If you say it shouldn't be man, it can only be a woman.
Could you unpack Justice Gorsuch's concern about the massive social upheaval? Because I know in a lot of circuits, as we discussed, sexual orientation, gender identity are already protected. Mm-hmm. So what do you think about the likelihood?
I mean, so I'm not sure exactly what he was talking. He used the term massive social upheaval. I think that was an exaggeration or a little bit of hyperbole. At the end of the day, again, I think it really was just more a question about, is this the appropriate judicial role? It's the old question of when you want to accomplish something like this, should you be doing it through the democratic process? And I've sort of talked about how we have a lot of failures and process problems there versus courts and judges doing it. So I really think it was more just about, is this a more judicial modesty argument? But again, he may not be aware. You assume the justices read briefs and amicus briefs and absorb all this. But just as in the gay marriage case, we said this will be massive social upheaval if the Supreme Court decides gay marriage. Well, gay marriage was already legal in more than half the country at the time of the Obergefell decision in 2015, and right now, I believe it's the case. I mean, so in the sexual orientation argument, 2 of the 11 federal circuits, 12 federal circuits have gone along with that. I believe it's more than that on gender identity. So it is already the law in substantial parts of the country. It is already a matter of federal court decisional law that gender identity discrimination is sex discrimination. So I think the massive social upheaval, it may be just a way of saying, won't there be a lot of blowback against us? Won't I, as one of President Trump's nominees, be accused of being a faithless, conservative and Trump judge if I do something like this?
And I think there was a lot of talk about, like, in terms of the social upheaval, about sex-segregated restrooms and dress codes. And I think that was one of the things that they were referring to when he was talking about this massive social upheaval.
Yeah.
And it was pointed out that there was transgender people in the courtroom at the Supreme Court hearing, and that there was a transgender man who was at counsel's table who followed the male dress code, because there is a dress code at the Supreme Court. Men are supposed to wear ties, and women aren't. They don't have to wear ties. So, but I also think that it's just, to me, it goes against the grain of textualism. If you're a true textualist, you don't look at the massive social consequences. But if he is going to look at that, if he's going to look at the social consequences, well, I think what's good for the goose is good for the gander. Maybe he should also look at the incredible, grievous social harm that would be caused by a ruling that would allow employers to discriminate against LGBT people. I mean, I think we all know the statistics about, especially, transgender people of color and what the kind of social ills that befalls them. I mean, and this is just one piece of the puzzle, is employment, but it's a grievous social harm. And so that if he's going to take into consideration the massive social upheaval, it seems like he should look at everything. But I also think that it's counter to the textualism argument, which really, I think I've read a few articles talking about how this decision is going to test whether or not the methodology of textualism is going to be true. Because if they follow it, then they should rule in favor of the LGBT workers.
My question is for Ms. Hively. I was just curious to hear what would a victory at the national level at the Supreme Court mean for you personally?
It would be the best thing I can imagine. We passed marriage laws, which was a huge step. But if I took that, especially in my case, and here in the state of Indiana, which tends to be a little behind a lot of the laws nationwide, I could get married on a weekend and by Monday lose my job, kicked out of my house if I were renting, and be denied loans because there's nothing that protects me from that. So even though it's a win in this column, there's all this other blowback that, that can create. So having it be equal across the board would be the best thing that I could imagine.
All right, I think that's a really good note to end on. Would you thank the panelists one more time? And there's Mango Cafe outside.